waiting for some more participants to join us, and as soon as we do have decent amount of students joining us, we'll be proceeding with it. I do see that we have a speaker already who have joined us, so let's just wait for another couple of minutes. I think that is a fair enough time, and then we can get started. If any of the student can quickly confirm via chat or something whether I'm audible, that would be really helpful. Okay, great. Thank you. Thank you, Meenal. Thank you so much. I think while we are waiting for more students to join, I think it's an onus on me that I should at least thank everyone for joining us on Saturday. Uh, this is a workshop that we did plan to empower and to encourage you to participate in the moot court competition. So I think it's worth attending it, even if it's on this weekend. So just bear with us for another 2 days. We have it today and tomorrow at the same time. Now, okay, yeah, let's wait for another 1 minute and then we can start. Okay, I think we have a good enough number to get ourselves started. So again, a very good morning to all of you, and thank you once again for joining us on the weekend. I'll be moderating the session today, but apart from that, I will also be introducing the structural layout of what we intend to do for today's session. So over the last 1 week, over the last couple of sessions, we have been trying to deliberate on the conversation, at least starting that interaction on what are the essential components of moot court competition. Now, today we proceed to something which is much more central to the entire premise of moot court competition. अभी तक जो हम बात कर रहे थे, we were talking about drafting the moot memorial, we were talking about how to read the proposition, but today we come to the core of moot court competition, that is how do you plead. Many of the moot court competitions might have that option that they don't really give you an option to submit memorial or nothing, but however at the same time oral pleadings runs at the central of any moot court competition, and this is a must. So on that note, I'm just going to start with a small imagery, and let's see if I hope my slide is also sliding when I'm moving across. Can you guys see the slide by raise of hand or by any indicator? If somebody could, is it visible, the slide? Okay, great. Thank you so much, Jitaksh. So now this particular slide has two imagery. There are two images, and there is a very subtle difference between them. Now, due to paucity of time, I ideally would have asked you people to spot the difference, but I'm going to just proceed with this difference. And there is a difference. This particular representation of image also tells us about two ways or two different ways of how a moot court competition or how a different competition works out. Now, if you look at the first image, the one that has a emblem of Mass Washington and Lee School of Law, the pleader over here is standing and pleading before a panel of judge. When you look at the image in the right side, you see that the people who are pleading while sitting. Now, this is one of a very, very, very small difference between a moot court competition and something like arbitration competition, wherein a moot court pleader has to stand and plead. In an arbitration proceedings, a presenter might sit and plead. The importance of it, such a trivial difference, is to tell you that why in the case of moot court and why in the case of oral pleadings, you should be you should be cognizant of the process. With that, I proceed to my next slide. Now, when we talk about oral argument, one thing that I, as somebody who is experienced of pleading as well as researching, would say that the entry point of preparing yourself with the best practice is to familiarize yourself with the process. It is very important that you have researched the rules governing how your moot court is to be conducted, considering that there are plethora and there is a diversity of procedure. Now, the reason as to why I'm harping upon this process is because if you feel comfortable, you need to feel comfortable in the moot court environment. There is already a lot of onus, there is already a lot of stress. One way of gathering enough courage, or one way of making yourself confident, is how familiar are you with the process. You will feel a lot better and less stressed if you are aware of the surroundings, if you own those surroundings as something that are much more comfortable sitting. The second aspect, and I think Asad is going to dwell upon a much more pragmatic approach. I'm just taking a bit more conceptual. I just thought that I should, as an internal faculty, I should share some of the limitations and some of the limitations of moot court pleadings. Now, think about it. When you present an argument before a panel of judge, you have to be cognizant that your audience, in this case, in the case of moot court competition, may have different ways of understanding the presentation of your argument. No one in your audience will think in exactly the same way as you. You are the one, along with your team, who has researched on a particular moot proposition for, let's say, a couple of months or even a couple of weeks. The judges who are going to be adjudicating upon you might not have perused through the proposition in the same depth as you have. So they might not be in a position to have a ready idea of how your presentation, how your structure is going to be. And that is one of the limitations because of the paucity of time as well. You have a limited, most of the moot court competition comes with a limited set of time, which is to be given for a speaker. You might have 15 or 20 odd minutes to convey your entire process, to convey your arguments. And one of the limitations that you should be aware of, that it might have the potential of not reaching them in the way you would like it to. There will be a diversity, there will be open avenues of interpretation. And that is an inherent flaw with communication skills. So how do we mitigate it? And how do you confront this particular challenge? Now, this is something wherein Asad will be speaking a little bit more, considering his pragmatic experience. But as I stated, one of the entry point is to familiarize yourself with the procedure. And when I say familiarize yourself with the procedure, that also includes an intangible concept of familiarizing yourself with the expectation of judges from you. You need to know who the moot masters are. They might be some eminent judges, jurists, experienced practitioners in the relevant field, legal academics, coaches of other teams. Your challenge, which you have to fulfill in, let's say, 20 minutes, is to develop a submission that will appeal and impress every type of moot master. And I think it's a hard ball game to play, considering that they, as I stated, they might not be as well versed in depth as you are with your moot proposition. And there is a certain level of predictability that what their expectation ought to be. But then at the same time, I did sound on a very pessimistic note when I said that there is going to be diversity of expectation from you, but there are certain best practices that you can follow, that you should follow. So on this note, I think that's a kind of a little bit insight of what I felt everybody should be cognizant of, that when you are pleading, there is a chance, or there is an avenue that your panel of judges might not get the gist or essence of your argument, and that is wherein you have to challenge yourself. You have to make sure that your argument reaches them in the way that is best suited to yourself. On that particular note, I'm gonna pass it to Asad. Asad, are you there?
Yes, thank you. Am I audible to you?
Yes, yes, you are audible. Asad, before I, as a moderator, I think I should also, I think all of us are already introduced to you, so I'm not going to reiterate it. But again, a very, very thank you for up for this, for allowing us to listen to you on Saturday. I think it's a big deal for you as well. So I hope I was able to set some groundwork for you to build upon. So yeah, I think I will pass it on to you. If you would like me to try, if you can share your PPT. If not, then I'll be more than happy to moderate it for you.
Thank you, Aditya. I'll put the PPT from my side and I'll see if it works. And you put most of the ground which I was supposed to discuss. Okay, I hope it's visible.
Yes, thank you so much. Yeah, it's visible.
So this is a very interesting topic, like oral arguments and moot court mannerism. And you began with a very important task, which is understanding of the judges. Especially when it comes to the domestic moot court competitions, it's difficult because most of the time we have judges which are coming from the traditional set, and also some of them are not aware about the facts of the moot problem. So you have to face the judges, especially in the prelim rounds, where the judges might make it very difficult for you. But again, we will come to that one later. Okay, so moot court, oral arguments, and moot court mannerism. This is something which you will have to practice over the period of time, but irrespective, even if you're doing it for the first time, you can do it really good. So oral arguments can be divided into three particular elements. One is the structure, the other one is form, and the third one is content. They all are equally important. And you cannot just skip any one of them conveniently, because all of them has the weightage of the marks. The structure is something which, again, you formulate in your mind, firstly, that how you're going to present your arguments. Because whenever you have written your memorial, there's a difference between the oral argument and the written memorial. Because the written memorial is going to be read by someone, so you don't have to keep the things simpler. You can put the point-wise and you go ahead. But when you're speaking, most of the time, the judges, they get impatient when they do not hear something which they expect to hear immediately after you have brought the argument. So therefore, you have to structurize in a manner whereby this curiosity of the judges, whether you are going to attend a particular argument or not, has to be introduced. So therefore, structure becomes very important, whereby you open your argument in certain number of folds, but is still introducing each of the fold in the beginning, so that they will be aware that you are going to argue on this particular issue. So I have, like, for example, put over here some examples. Coming with this one example, which is from a GD Goenka moot, which some of my students are doing, which is today. So I thought it would be okay to just take it up. So they had this one particular issue. It was an arbitration moot, and the issue was right before you. So for example, except from those introductory part, which you see most of the time regarding when you first proceed before the judges or the arbitrator, you have to introduce yourself that you are the counsel on behalf of the, or agent on behalf of the claimant or respondent or petitioner or respondent, depending upon what is the nature of the moot. So therefore, when Aditya sir was telling that to familiarize with the structure of the moot, it is very important that what kind of moot you're doing. Not all the rules apply for every moot. So let's take one simple example with regard to arbitration. It's not a very formal process. So you are not going to use the word much obliged or all those fancy terms which are used for the judges, like your honor or your excellencies. You simply go ahead and you present your matter before the arbitrators. You refer to them as like, if they're like more than one arbitrator, you will say them, you will just say either like to one Mr. or Madam President in arbitrators, or you just say Mr. Arbitrator or Madam Arbitrator, the counsel on behalf of the claimant, because again, you see the terms are very, you have to be careful with the terms. So in the case of arbitration, you're always either the claimant or respondent. If you're going before the national courts, you're the petitioner or appellant, or your respondent, depending upon what is the nature of the petition or the case, whether it is the original case or the appeal. So again, when you go before the international courts, you will see that you go as prosecutor or the defense. So again, you have to be very careful about what is going on over there, so you do not get confused. So just this example. So I just pasted it over here that the council was supposed to move with the next issue. So you introduce proceeding with the third issue. The respondent contends that price escalation claimed by the respondent is valid. However, this particular issue was entirely a big issue, which came as whether the price escalation claimed by this particular company is valid or not. And then there was some further lines which was there. So you see, when you are directly arguing, you don't have to, start with a whether, because that whether is an issue, but here you are directly asserting your claims. So you go directly with the argument that what is your contention or what is your assertion, okay? So here they simply went that the price escalation which was claimed by the respondent is valid. And then you keep it very simple. Your arguments are twofold. The first, the price escalation claimed by the respondent is valid. Secondly, the price escalation certificate produced by respondent is reliable, because this was the two question which was challenged and this was supposed to be argued. So you will always have to introduce the elements upon which you are basing your arguments. Now, this is easier to do when you are writing, because you just introduce it like point-wise in paragraphs and you expect the reader to read it. But when you have the impatient judges sitting over there who are looking forward to whether you are going to address a particular issue or not, you will always have to introduce the elements of your argument. So the first element was whether the price escalation claimed is valid, because this was again a question that the price escalation which was claimed, it was not within the scope of the contract entirely, because the contract had already expired and the price escalation was claimed after the expiry. But again, there were certain other reasons upon which the respondent were basing their argument that there was an extension of the agreement between the parties. So therefore, the first argument, they were starting from the validity of the price escalation claimed. And the other argument is the certificate for the price escalation, because once you have established that the claim of the price escalation is valid, which is again arising from the terms of the contract, the second argument was that again, in the terms of the contract, it was stated that the price escalation has to be proved through a particular certificate, which was supposed to be provided by the party, again, coming from a well-recognized price agency, okay, which was agreed again in the terms of the contract. So this is how you will go. Always have to keep it very simple. Then you go ahead. Once you introduce, you take a brief pause, and then you say, like, Mr. Madam Arbitrator, proceeding with my first submission. And then you make your argument, and then you make a concluding sentence. So for example, the respondent, they made the argument that the price escalation claimed does not entirely fall outside the scope of the contract, because there was an implied intention of the parties that time was not the essence of the contract, because the parties were well aware of the fact that the services extended by the respondent was time consuming, and there was certain modification in the contract, and time was also extended through an additional agreement between the parties. And you provide your legal principle first, okay? And then you go with your factual analysis, and then you again make a final conclusion. Therefore, it is contended or it is concluded that the price escalation claimed by the respondent is valid. Proceeding with my second fold of the argument, the price escalation certificate produced by the respondent is valid. Then you go ahead with, again, the legal principle which you are supposed to introduce. Now, most of the time you will notice that sometimes the student, they get confused at how many cases do we have to cite. You don't have to cite so many cases. Again, because time is very limited, you have to cite one dominant or most prevailing legal authority. It could be a, it could be simply a legal provision. And if the legal provision is complex, you will have to get with the interpretations made by either any judicial body or non-judicial bodies, such as different arbitration proceedings or arbitration cases. Sometimes the judges will bug you with the questions why you are citing a particular judgment from a foreign jurisdiction or an arbitration case, because arbitrations are not having the binding decision on the other arbitration proceeding. But you see, the thing is that you have to stay prepared about these questions, because this is very common that sometimes they do not let you speak. So you have to be careful, especially this happens during the preliminary round, that they will try to test your knowledge by asking you random questions, which is not even connected with your issues. And again, you cannot avoid them, but you can also, one thing is you stay prepared. The second thing is you pray that you get a very good judge who listens to your argument. But stay assured that after the preliminary rounds, especially in the semifinals and finals, the judges, they listen to you very carefully. And especially in the international moot competition, they will not interrupt you until you are making some very big deviation or you're making a wrong argument. So therefore, it is very important whether you present one legal principle or two, you have to make a legal principle correctly before them and not make some incorrect or try to bluff them, because they will catch you. Okay. So this was one example. Then again, the second example, which is over here, is that choice of the words. For example, some of my students, they were doing the same determinant moot, and they used this word like factual matrix, and they said, Your Excellencies, para 19 of the factual matrix. Again, the word factual matrix is not something which they should have used. So I wrote it over there. And then again, I highlighted it because when you are dealing with the International Court of Justice or Supreme Court of India, where, I mean, obviously these moot problems, they are coming from the fictitious background, but the courts are again giving the same standards or stature when you are arguing. So you will be using the same manners. So you will say, Your Excellencies, I would humbly like to draw your attention to paragraph 19 of the fact sheet. Use very simple words, no fancy words. And then you will pause and say, the states that is not necessary. You will simply say, once you have already drawn, they will be able to look into it. And then you go with the argument, which was the fact. Now, again, I said this over here, how does this para and the para below suggest the absence of the common plan? This is one of the major problems which these students suffer, especially when they have not done their own research at the time when they were drafting the memorial. They leave it entirely upon the researcher. The researcher has a good knowledge base, but when the speaker, they do not do the research, they fail to understand that why a particular argument is put forward and why this particular legal principle fits into it. And they bring a very wrong fact. Now, the students were trying to bring that there is an element of this responsibility regarding the contribution of the crime in the International Criminal Court. So there was a element which requires that there has to be a common plan. They put the whole fact which they felt that this suggests the common plan, but it did not. I mean, you will have to understand that whether the legal principle you are citing is connected with the fact which you are trying to establish. Now, I'm not saying that all the students do it. Some of the students, they fail, especially the one who are trying to do it during the, for whom it's the first moot or the second moot. So understand, this is not an examination where you have to just fill the paper and just get away with it, that you have to speak something. You have to make a very precise argument. The existence of common plan in this particular example, which you are seeing over here, is not established by that there was a mechanized infantry or that there was, that there was a gunner and he has the discretion of firing. The common plan has to be established or negated from the fact that the defendant and the government, they had a meeting for procurement of a particular technology, which was supposed to be used as an automatic target acquiring system mounted upon the weapon of this particular state. And the defendant agreed that they will provide this targeting system, which will use the artificial intelligence to target the combatants. Now, this particular fact can link that there was a common plan because the defendant and the state they had met and they decided that they wanted this system, AI system, and the defendant provided them. And therefore, since they were well aware of the fact that the state in the past has a very bad record of killing the civilians. And despite this fact, the defendant yet still provided this artificial intelligence. Therefore, it shows that there was a common plan between the defendant and they were trying to facilitate the commission of crime because of these facts. So again, the point here is to tell you that when making an oral argument, you have very limited time. So please be precise and do your best to present the facts very briefly.
I think Asad
Okay,
or
sorry, I
yeah,
got muted. Okay,
I think we lost you for a couple of seconds. So
okay. What I was saying, the point here is that you have to be very careful that you have limited time. So please be precise that you are not making or taking too many arguments or facts in order to prove your point. It has to be very precise fact what you are trying to say. So moving to the next thing, which is again, you have to engage and not simply narrate. This happens when you are doing the moot and you take it as an obligation and you are very much nervous, which is okay. Whether it's your first moot or your 10th moot, you will always be anxious and nervous. But the point is that this can be avoided if you do a prior practice before your mentors or your seniors or among yourself. Now, the best thing about these days is that you can do it behind your computers and you don't have to be physically present because most of the moots are they are held online. So it gives you this comfort to stay at your home and like comfortable place and do your arguments. Now, again, when I say engage and not simply narrate, it means that you do not want to just read out something or spill something which you have memorized. You have to understand that what judge is expecting, which is again, it was pointed by Aditya sir, that sometimes when you are over there, the first instinct of the judge is that they will ask you, please introduce yourself. And then you have to understand that you have introduced yourself. And when you again begin with your submissions, you don't have to again, like go ahead with like, may it please the court, I'm the counsel on behalf of the respondent, or because you already introduced yourself. So you will simply go ahead. If it may please the court, I would like to proceed with the submissions with the permission of your lordship or like your excellencies, and then you go ahead. Or maybe if you are the petitioner or the first party to argue, you will have to introduce the facts very briefly. The tactic of doing that, usually what happens, the students, they try, which I noticed, which consumes a lot of time. They say, your lordship, I would like to, if your lordship are not aware of the facts, I would like to proceed with the facts or brief assertion of the facts. Now, most of the time, the lordship will say, please go ahead with the facts because they do not come prepared with the facts. Especially during the preliminary rounds, they just come in the morning. And I have seen this because I have been in some of the moot court competition as a judges, and so has been Aditya sir, and we know that the judges briefing happens early in the morning, which is like an hour before the moot. And since you are the one who has read the moot problem so many times, you're able to figure out all the complexities, but they are unaware about them. So the best thing is that you simply introduce the brief fact when you are, coming with the introduction itself. So for example, you go ahead that I'm the petitioner representing the name of the party, you say, and then you go ahead that the present petition or the present matter arose from this fact, and the questions before this particular court or particular tribunal is this. I am the first counsel, and I will be addressing this issue along with my co-counsel who will be addressing this issue. We shall be taking this many minutes, okay? Or you can go ahead and introduce first that I'll be addressing these two issues and I shall be taking this many minutes, or I shall speak for this many minutes. Subsequently, I will invite my co-counsel. All of these things, you can find it from the YouTube videos, which you can see from Google as well. So that isn't a problem, introduction and conclusion. Problem is that when you memorize and you feel that everything is going to happen according to how you prepared, but things a little bit changes because the judges, they throw some random thing at you that please tell me this fact, what are your issues? And you plan that I'll unfold the issues before him in this manner. And then they directly ask, what is the issue? What is your claim? What do you want us to do? So these could be some random question which the judges may ask. So you have to be careful about this and aware, which others have told you, be cognizant about the environment. And this will be essential, especially when you are doing it online, because online is difficult. So one thing I always suggest, never keep anything on the screen. You just see the judges on the screen and nothing else. If you want to address something or you want to refer to something, keep it in the printed format. Because what happens if you get distracted because something is on your screen, it puts a wrong impression on the judge because they can see the movement of your eyes. Plus, you are unable to see whether the judges are raising hand or they have a question or they are unsatisfied with your argument. The second thing, do not interrupt or jump ahead of them whenever they are asking question. Please carefully listen. Sometimes when they're asking the question, you start formulating your answer in your head and you skip that what was the second question. So you have to formulate the answer, but be also careful that they are not finished yet. So they might have some different question. Once you listen attentively, you will be able to address all their concerns. Still, stick to the structure, but whatever they are asking, accommodate to their needs. The next thing is the mannerism. Now, mannerism is something which you will have to practice and you will have to understand by observing the other, winners of the moot court competition, which again, like luckily we have YouTube, you have internet, you can see all of that proceeding. See how it is being proceeded by the winning teams in the international competitions, national competitions. Do not be very aggressive. Sometimes the student, they make it dramatic. You can make it dramatic if it is a trial moot, but if it is a Supreme Court, if it's a matter like writ petition before Supreme Court, it doesn't have to be dramatic. It has to be polite, assertive, and if it is the international moot, then it has to be very boring actually. But again, the point is that you shall be able to put forth your argument in a very simple manner, not very complex manner, not very complex word, because writing is another thing and speaking is a different thing. If you put too many complexities, they might not be able to grasp you and they might lose the attention. Keep it very simple, okay? Right selection of words and phrases. The reason I'm saying is that, for example, sometimes students, they use certain words which is impolite, and sometimes they use certain words which is not like, a kind of tradition in that kind of mood. For example, I've seen this word often used by the student that I would like to present my arguments in 3 limbs. The first limb, second limb, and go like that. And limb will work if you're doing an arbitration because that is not very formal. But if you're doing an international mood before ICJ or like your national like court, like Supreme Court, High Court, the limb is a very informal word, okay? So again, the second thing is pause and timely use of salutations. You have to use salutations even in the middle of your arguments. And pauses. Pauses and salutations will help you in dividing or demarcating the boundary of your argument, which is getting concluded, and the next point which you're going to start. Okay, so for example, you concluded with the first submission of your argument, and then you want to proceed, then you pause briefly and then said, Your Lordship or Your Excellency, beginning with the second submission, then you go ahead and then again you conclude. So let's say you're going to introduce a new point. You can use pause, use the salutation, and then you introduce a new point. This will give a hint that you're introducing a new point or you're making, let's say you were like citing a legal precedence, you pause and then say, refer, Mr. Arbitrator or Your Lordship, in the present case, or you simply go ahead. Because in the present case, if you say it so many times, it will look very, very boring and it will be like problematic sometimes, depending on the judge. So you can use the word Mr. Arbitrator to, distinguish now the legal precedent, like legal principle you stopped, and now you're moving forward with the argument. Stay humble, even if you disagree, okay? Do not show I know it's very difficult to keep it on the face straight that you are not, I would say like irritated, because some judges could be very irritating. and you still have to be, humble and show that you are humbly disagreeing and this is what you would like to put forth. Okay, but again, humbly, eye contact is necessary. And the last thing, reading from paper. Now this thing goes both way. Even either if you're reading from paper or if you have memorized something, it could feel like that you have memorized. Okay, therefore you have to take brief pauses. You have to take these sentences in a format whereby you are not feels like that you are reiterating something you have memorized, but rather you are engaging with an argument. And reading from the paper is not a problem. Always print out, if you're doing it online or offline, always print out your speech. Because if you miss out something, it is okay to look down and just quickly refer. And this is why I always tell students to prepare their speech. And they said, like, sir, we have to orally argue. I can do this. A speech will allow to have your well-structured argument. Even if you forget something, the speech will allow you to look down immediately and refer to what was the line of the argument. What is the next argument in the sequence? It will also allow you to keep your arguments coherent, because when you keep practicing and you keep interacting with your guide, they keep telling you new things or new elements and you forget. अगर आप notebook में लिखेंगे, you forget immediately. Always update in your speech. Put it in the comment or a citation as well. If they ask you that what is the authority, keep it in the citation so you can immediately refer it from one single document. All the updates, all the corrections happen in one single document so that you do not get confused that last time the teacher had told me this and this time it's coming like this. It shouldn't happen. This is why speech is necessary. Even though you don't have to read from the speech, but it is necessary for your own convenience to formulate the structure of your argument. And lastly, concluding the submissions. That when you're concluding your submission, you always make a final conclusion, which is that you are, therefore, this is the particular contention which can be concluded in this manner. If your lordship or the arbitrators are satisfied with the argument, I would like to invite my co-agent, co-counsel, and then you seek permission, say thank you, and then your co-counsel come, they will introduce themselves and go ahead. And finally, the co-counsel will, address the final conclusion that therefore we are, concluding before this, and this is our prayer or this is our request. Do not wait for the cue that now what? Usually what happens when the first counsel, they speak and then they finish the argument and they start looking blank, waiting for something the judges to say. You simply go ahead and say that now this is the submission has been concluded. And if you do not have the question, I mean, politely, depending on what the scenario is, you invite the co-counsel. Then co-counsel, after finishing, do not wait the judges to leave out a queue. You again make the conclusion and seek permission for the prayer. Now, when your time limitations are over, let's say if your time limitations are over, then you do not seek extra time for the argument. Let's say if you were in the middle of an argument and the judges want you to answer the question, you seek permission from the judges for completing the answer and then seek permission for making the conclusion. Do not use that time to, put new elements or arguments. Conclude within a minute directly what your contentions are. Okay, even if you miss the entire argument, just conclude that this is your contention in one sentence and then finish it. Okay, always seek permission and do not try to bluff or do not try to, prolong your time which has been granted to you. So this is most of the thing. I hope I did not take excess time. And yeah, thank you very much.
Great. Thank you, sir. That was really helpful. I think if there are any questions for him, or if there are any concerns, or if there are anything that you would like to share, please put. This is out for all students. If you have any questions for him or for me, please put out it on the chat box, or you can ask us to unmute yourself. We'll be more than happy to do it. Uh, I was while I was listening, I had one question. If Asad, you allow me to
Yeah,
ask.
definitely.
I had one question. It's not a question. It's just something that since you mentioned that we've been we've been together as a moot court judges on many
Right.
competitions, and I always felt that when there are questions posited in the middle of the submission by the judges, and when once that while answering that question or while responding to that question, after that it is it becomes really challenging for a person who's pleading to go back to his or her structure. And I think that's one thing when I have seen students struggling a lot to resume or to retain the structural coherence of their arguments when they are being interrupted. Interrupting would be a wrong word to use, but when they are being intervened by the judges, and when they, when they start responding to the judges, because they also have a stipulated time limit. So just wondering what, if somebody, if for one, some of our students struggle with it, what would be your response? What would be the best practice to go about it? Did you get my question?
Yes, thank you, Aditya. Yeah. And to be very frank, this is a very difficult and complex situation. But again, a lot depends upon the nature of the judge. The first thing is that you begin by listening to the question attentively, and you have to present a face whereby you are focused and paying attention to the judge's question, which allows the judge to be, you know, aware of the fact that you are not dismissive of his question, or you are not, challenging his question or simply going in the flow of your own argument. So you carefully listen, and then you thank you him for the question, and then you bring the concerns which they have posed to you. Let's say sometimes they simply ask the knowledge question. For example, they will ask a term which you have used, okay? Or they will ask you something which you made an argument, is it correct or not? Or they will ask you what was the facts in this case. So again, these are all the things which come from the preparations. And sometimes you might not be able to know the answer because they have asked them you a factual question, which is again the knowledge based, but you do not remember because it's a fact. So you simply tell them that like you seek apologies because you're unaware of this fact. But if it is a logical or argumentative question, you will have to address the concern by in one or two line, or let's say you're already addressing in the further. So you do not, either you seek permission, that I seek permission, your lordship, if I would like to address this question in the future because it has been covered in the second issue, or if they ask you, no, you have to like present it right now, then you present it right away, but very briefly in one or two line. Again, you do not prolong it. This is what the judges, they sometimes do not like, because when you prolong, it feels like they are getting challenged, okay? And then they will pose the next question, what about this? So you simply you address their concern in one line or one sentence, that this is it. If it is something which requires too much argument, which you have already addressed, you make them aware that this has been covered in this, but do not keep it long, their question. And this is why this will be easier for you to come back to where you were arguing if you keep your answers in one or two sentences. But if you prolong it, you will skip or miss where you were arguing. And coming back to where you were arguing, again, you seek permission. If the lordship is satisfied, I would like to continue with the argument which I was making. And this is where your written speech comes into help, that you can immediately look back and see that where you are, because sometimes we get lost, and it is okay, everyone gets lost. And sometimes what happens that judges ask you 3 to 4 questions in a go, and you will have to like remember all of them. So you either the researcher will put it down immediately that what were the questions which were addressed. If you miss the question, you can again apologize, seek like pardon, and ask the judges that what was the other concern, but you will have to address all the concerns. If you don't, then they will again, they will feel like they have been ignored, and that may leave them. But again, the thing is like, this comes from the practice and the knowledge base. The knowledge base has to be acquired. And this is why I say, do not leave the work on the researchers. You will have to do all the work as a speaker. And this will allow you to have that knowledge in order to answer the questions the judges are asking. So I hope that helps.
Oh no, that's I think yeah, it's thank you so much for that answer, because I was reflecting about it, and it is some of the struggles that I've seen students facing a lot. So yeah, but that answers a part of it. And I think I really for me, one of the takeaways from today's session with you was there are two components of discourses that happen. And I really like the slide when you stated that it's also about engagement and not narrating. Now, I think this is, I'm also talking to the first year and second year law learners who are going to be participating in the near future for the very first time. I think the essence of the moot court competition lies in this particular premise which Aksad was bringing about, that it's also about engagement with a concerned party, let's say judges, rather than narrating. They are not going to be, they're not really, they're not really harping upon how much you have memorized and how much of it is being retained by you. I think they are also, like, as Asad mentioned, that we have been judges in many competitions. It's also about how we look at it and how we would like to be understood. So that's one thing that I really liked about today's presentation. That's a takeaway for me as well. As how do I inculcate culture of mooting in our students in such a way that they are propelled to engage rather than narrate. The second aspect is about the speech. I think that's a very interesting entry point, because we have been traditionally, when we have been looking at the moot court competition, it is being often stated as a strict no that you should not look at the paper, you should, you should face the judge and having an eye contact. But at this junction, I think it is also important that it's okay to stick to your structure. It's okay to look down once in a while if you need help. We have the system when we take assistance from the researchers. It's okay to do that. Nobody's going to judge you. At least the judges will not be picking upon that aspect of yours, that you have looked down or you have taken help from the sheet, you have taken help from the researcher to formulate your argument. So that's some of the takeaways for me, and I think our students are also going to take certain things from the session that you delivered. Sonali ma'am, if you have anything to add, and if not, then I think we'll be good to go.
Hello, Asad and Aditya. Actually, I was listening to the presentation and the aspect where you were discussing about the mannerism. So, Asad, I would like to know, I need like to understand on behalf of the students that right now, like we are going with the virtual mood courts, online mood courts. So sometimes it becomes very difficult for the students to like properly present their points or present their arguments to the judges. And like we all know, the judges can be academics, can be lawyers, so there can be a different type of opinions a judge is holding. Like sometimes you find a judge to be very stubborn and they doesn't want to listen to the points, they doesn't want to listen to the arguments. And there can be other reasonings also, factors like for example network issues or some things which can actually at some point agitate the students, or they're not able to take the points which are made by the judges or understand the points which are made by the judges. Or even if there can be a situation where by any reasoning the judge makes a wrong question, a wrong argument or wrong principle. So in these scenarios, how should a student like handle or tackle with the things?
Thank you, Sonali, for the question. Of course, it's very difficult after the things have become in the online mode. However, one thing which I felt could be done in this regard is sticking to the time limit. When we are speaking in a physical setup whereby we have judges right in front of us, it's easier to assert our points by using a little bit of hand gesture, because again, as a moot student, like they are not expected to use too much of hand gesture, but it's still like the facial expression and the hand gestures, they do the work. But in the online setup, it's mostly what we are saying and how we are saying. So the network issue is something which is, I do not know how it could be addressed, because it can happen suddenly anywhere. But again, when this happens, they provide the extra time. But with regard to the understanding of the question of the judge and presenting the arguments properly within a limited time, I feel that to secure a lot of time, and this is where the speech also comes into the play. If you prepare the speech and you read it out slowly, you will know like how much time you are consuming. And if you're receiving a 15 minutes of argument time, this speech after reading it word by word shouldn't exceed like 9 minutes. Because again, when you're speaking, the judges will ask question, and the speech will give you an idea like how much time it will take. But again, When speaking in the online mode, it is very important to speak slowly and keep the arguments and points very precise. The nature of the argument, if it will be precise, the judges will have lesser questions. And even if they do ask questions, you will have enough time to answer their question and still continue with the argument, because during the oral argument, everything comes down to the time. It's a very time bounded setup, and the judges, they are also looking for very precise answers. So I feel that making the arguments short and precise will help these students to present and tackle to the question of judges and still not feel that they missed out something. So if they are well prepared of the thing that they have to present the argument in a very limited time, then there would be lesser chances of being or missing out something. But when you prepare a lot of argument and you feel that because the questions were asked too many times, the judges did not take it, therefore I lost the time. So you go prepared with this, that there will be very limited time, and the judges are only stubborn when you bring something which is something either too much deviated from the point or it is incorrect. If you make a very correct argument, judges, they will bug you with certain further question to test the depth of your knowledge, but they will not go further and disagree. This is why it is important when you're arguing never to bluff, always be very precise with the argument and legal principle. You can use more the arguments or interpretation of the facts in a way whereby it supports your argument. But again, do not introduce new facts or something which is not even in the fact sheet. So these are a few things when paid attention to, it can be, the situation can be avoided on the online setup. The precision of the argument, slowly speaking, and again, saving a lot of time. Yeah, I hope that answers the question.
Thank you. I think for me, at least, it's due because I don't know how long we are going to be in a virtual arena. So I think it's better we get used to with the things of that. So thank you so much, Asad, for that.
Thank you, Sonali.
So if there are, let's have a last call. If there are any questions for us or for Asad, please kindly write them in a chat, or you can ask us to unmute yourself. I don't seem to think there are any questions. So if there are no questions, then I think we shall call it a day. Thank you, everyone. Thank you, Asad. Thank you. Thanks so much for being part of us. This was your second session with us, and we do hope that we get to see each other and we get to invite you personally to have a conversation with our students who are interested in moot court competitions. It would be a delight to host you as somebody who has worked with you previously, and as also somebody who's learning along with you in the
Of course, I have learned a lot with you.
So thank you so much, Asad, and thank you, Sonali, for
thank you, Aditya. Thank you, Sonali.
Thank you, everyone.
Thank you.
So I think we'll call it end. Tomorrow we also have a session with Afzal Badr Khan around the same time. Please make sure that you guys attend it. That would be our concluding session on the art of mooting workshop. So yeah, make sure that you guys are there. Thank you so much. I think I'm gonna conclude the meeting. I'm gonna leave it. Great. Thank you, everyone. Have a nice day. Bye.